Morning Startup and also tell you about a few things that are going on in the community. I'm Justin, hopefully you're here for Morning Startup. I'm very excited, we've got a very special session for you this morning. But I'm going to let Charlie introduce that session and our speakers for you today a little bit later. Right now I'm going to tell you a little bit about Morning Startup and a few things going on in the community. We do this every 2 weeks. We're aiming to provide a forum for you for an introduction to the startup community. How many people have heard that speech before? Lots of regulars. How many newbies in the audience? First timers. Excellent. So we continue to see upwards of 7 to 10 new faces every session in Morning Startup, which is fantastic. I think that's testament a bit to the fact that our tech startup community here in Perth continues to grow as we reach into people that are excited to be starting their own businesses or curious about what it means to be involved in a tech startup. Very encouraged to see all of those new faces coming to events like Morning Startup. So thank you for being here. We hope that we can help you with understanding where to go next in your journey if you're interested in running a tech startup and joining one and understanding a little bit more about what this is about. We hope we can help you with that by providing access to expert speakers and an opportunity to network with some of your peers who have similar interests. So thanks for being here this morning. That's what we're about, and we'll do this every other Wednesday throughout the year. We do this with help from some sponsors, Beecham Group, principal among them. Thought I saw Robbie come in. Good morning, Robbie. Beecham Group is an organization that's aligned with our interest in seeing the tech startup community grow, and they are an excellent resource if you have a problem that can be solved with talent. For example, if you need to find a technical co-founder to get your business off the ground, I highly suggest you get next to Robbie when we've got time for networking later on today and talk about what they do at Beecham Group. In addition, we have a lot of support from Business News. We've got the CEO of Business News here today. Charlie Gunningham has graciously accepted a role as host of this morning's panel, and we'll hear from Charlie in just a moment. Also, highly recommend you check out Business News if you want to hear what's going on in the startup community. Largely thanks to Charlie's efforts, the Business News now profiles one startup each week, so it's becoming a great source of information on what's going on in the community. And SpaceCube, the fantastic venue for happenings in the startup community. We're here because SpaceCube is making the space available to us and to you. So thank you very much, Brody, wherever you're floating around the kitchen doing dishes. We don't have any formal slides for this morning. We have a panel of experts to answer your questions today. But before we do that, I want to share with you a little bit about the exciting things that are going on in the tech startup community. Amcom yesterday announced their tech accelerator, which will be hosted upstairs at level 9 in SpaceCube. Rob, do you want to say 2 words about that?
Yeah, sure. It's a mentor-driven accelerator program. So
we'll welcome Rob Nathan. He put the whole tech accelerator together. So let's welcome Rob.
Yeah, thanks very much, Charlie. Yeah, so it's a mentor-driven accelerator program on the 9th floor of SpaceCube. It's basically a collaborative effort between E-Group, SpaceCube, and Amcom. The program will provide $40,000 in seed capital for each startup in the program for up to 8 startups in a 13-week program commencing on the 1st of June. My applications will be open for the accelerator program next Monday, and there'll be an information session here at SpaceCube on Tuesday the 17th. So get along with the information session and we'll give you some more information. You can meet some of the mentors, some of the guys from Amcom, and some of the mentors from the program as well. amcomupstart.com.au. Check it out. Thanks, guys.
Excellent. How many of you have heard of On Earth before? A few. More than a few. Fantastic. That's excellent. On Earth is a national program this year about identifying the top talent in the tech community and putting them to work on solving the resources problems that can be solved by technology. That's maybe a poor way of describing the program. We're about creating a sustainable tech startup ecosystem in Perth based on the opportunities that are represented by one of our largest industries in oil, gas, mining, and construction. And last year we held our first hackathon here at SpaceCube in May. That saw upwards of 70 of Australia's top developers and data scientists work on a few problems that industry brought to the table, along with some data. People who participated in that event got to own their intellectual property, and the winners of the event in May went on to secure a place in our accelerator, which is about taking companies who have products that are focused on the resources sector from prototype to product in about 6 months. So that's another accelerator run out of Level 9 Space Cube upstairs. And I'm proud to announce that our second event will be held here in Perth March 20th of this year. And this week, early bird tickets will go on sale for that event. So that's, again, a hackathon event where technical folks largely can come and build prototype solutions to industry problems, and then they have an opportunity to apply for a spot in our tech accelerator after that. So see me when we have some time for networking if you'd like to learn more, or you can check out unearth.solutions. Other things going on in the community. Brody, you have things you'd like to announce?
Yeah, just really quickly. So tonight we've got the info session at the festival, which is Perth Festival bringing in artists to work with developers. So it's a similar sort of model of a hackathon, so it's next weekend. But basically bringing together, I think there's about 80 people coming along, developers and then artists to build new things. So the info session's on tonight, so anyone's welcome to come along to that. And start registration at 5:30. And probably also just mention OzApps. So OzApps is happening next week, next Wednesday, which is going to have a lot of people flying in from Silicon Valley and all over the place. But basically a day-long conference, learn from them, that sort of thing. And there's the OzApp Awards as well, where there's 5 stars, there's the Perth one, 8 mobiles. Yeah, so there's lots going on.
Yeah, fantastic. 2015 is shaping up to be an incredible year for tech startups here in Perth. We started Morning Startup probably about 3.5 years ago, and at that time there wasn't terribly much going on in the community. Those of you who have been here with us that long, I see a few faces in the audience that have been here that long, will remember sitting around as a group of 8 people sharing our experiences and trying to help each other out on our journey. Now look at us, we've got more than 1,000 members in Morning Startup. There are tons of other meetup groups for whatever your interest in the startup community. And now we've got at least 3 formal accelerators happening here in Perth, and lots of opportunities to find a path for your tech startup through to products available on the marketplace. So very, very exciting times. Happy to be a part of what's going on there. And I think you should all feel very excited to be here and know that there is there are growing opportunities for running tech startups out of the most isolated capital city in the world. So good on you. And I'd like to now introduce Charlie Gunningham, CEO of Business News, and a successful tech entrepreneur himself, who will talk about this morning's session.
In the room. Or any other newbies want to get up and promote what they're doing? Pankaj, no?
Yeah, why not?
Why not? Go for it.
Good morning, my name is Pankaj, and I'm starting a social enterprise called eKarma. It's based on the philosophy of giving it forward and karma. It's an e-commerce platform, so we get brands and companies who will donate their products and services to us, which we sell online through eKarma. The money goes to charities selected by the buyer and the seller.
Right. That's your 30 seconds. Good.
Thank you.
Well done. That's e-commerce. Okay, so e-commerce. Anyone else? You go? No? All right. Good. We'll get straight into it. Remember I did my MBA many years ago. I went into my MBA as a fresh-faced school teacher from England. You can probably tell from my strange accent. Down at UWA. My entrepreneurship professor said, when you do your startup company, bootstrap. The best thing I ever read was something called Bootstrap Finance by Arma Bida, B-H-I-D-E, 1993, Harvard Business Review, look it up. But, he said, do not scrimp on a good lawyer and a good accountant. About the best advice I ever had. Those of you who've been in some of the IP issues you can get into, I had 2, having a good lawyer on your side, having copyright protection, patent protection, intellectual property protection, trademark protection, and we've got 3 experts here. We've got a copyright expert, an IP expert, and a patent expert that have graciously come today to talk to you. I'm going to get them to talk for 5 minutes, and I'm timing you guys, 5 minutes. Introduce yourself briefly, and say like what area you're in, and maybe give one piece of really pearl advice that you've brought with us today. We won't be able to expand on it in those 5 minutes, but then it's going to be open to questions, all right? So if I introduce on my left, we've got Stephanie Faulkner from Wrays, who loves cooking and is a singer. And in fact, her brother is the lead singer for the Hoodoo Gurus. Isn't that right, Stephanie? And Guy Provan, and if you go to Guy Provan's website from Watermark, sorry, Stephanie's from Wrays. We're also a great supporter of E-Group, aren't they, Rob? So, Guy used to work at Freehills now, has been working at Watermark for 11 years.
No, just
You know?
7 years on my own.
Lebanese on your own, that's right, with a Watermark. Guy's got this lovely Lilson Scottish accent, which I think is fantastic. Go to his website, the About Us page, there's a picture which I much approve, him playing forward defensive with a cricket bat, which I think has got an analogy to, protecting yourself. That's what I tell my mighty Subi Maris under Blues cricket team, forward defensive, very important. And we have Rohan. Now, a lot of you know Rohan Wallace from Rohan Wallace, who's a big supporter of the startup community and pops up all over the place, and a big supporter of Space Cube, the startup community. So Rohan's here as well. And an interesting fact from Rohan, he attended, you're going to love this, geeks in the room, he attended the World Sci-Fi Convention in London last year. If that doesn't get your impression up for funky lawyers, I don't know what will. So without further ado, Stephanie, you've got 5 minutes to introduce yourself and bring forward something you want to tell these guys.
Okay.
Just welcome, Stephanie.
Thank you. I'm a bit too nervous, full of nervous energy to sit while I talk. Okay, so I came out of the music industry, not just because of my brother, but also because I was a lawyer and I did lots of deals, record contracts, management contracts, publishing deals and so on. And the thought occurs to me, whatever happened to the gentleman's agreement, where a man or a woman's handshake was as good as their bond? The reality is life has moved on. I don't know whether it's due to the global financial crisis, where everything now gets manufactured at the cheapest cost in a low-cost jurisdiction, where everybody is trimming their budgets as a means of trying to contain costs and increase or even maintain a profit margin of some description. But it appears to me business has become a whole lot tougher, and you have to become and do a lot of due diligence around who you deal with. Do you trust them? Are they the kinds of people with whom you should be going to business? Now, usually when you have some valuable intellectual property that's embodied in a product of some kind, you've got two decisions to make, first of all, before you, so to speak, lift your petticoat and show your ankle. And that is, how much do you trust to tell the person that you are talking to about your innovation? The second question is, do you keep any part of your technology as a trade secret, or do you patent it? I've got a couple of war stories to help you consider your options. And obviously they're not a blueprint, every situation will be different. First one, the confidentiality agreement, the NDA. I had a client quite recently who had a very innovative kind of axle device that could be used in many, many different kinds of machines and so on, and got a patent for it, and went into very, very deep negotiations and communications with a major international producer of a common consumer product. And they entered into NDAs. Unfortunately, they provided a lot of their know-how that underpinned the patent to this manufacturer for them to actually do prototype development in China. 3 years down the track, they still didn't have a license agreement. I got brought into the scene to try and sort out a license agreement. Everything went to shit pretty quickly, excuse my French, because we had, after exchanging several drafts of an agreement, we finally had a telephone conversation where it became evident that the other party had in fact used this period of time to engineer the product and work around the patent so that they didn't infringe. And they blithely walked away having, leapfrogged on my client's know-how and so on. So, very sad story. Due diligence, how could you have prevented that? I guess it's all about how much do you reveal and when do you actually have to stand on your hind horses and say, give me an agreement. Probably running out of time to give too many, so I might move on to the trade secrets part of it. That must be about halfway through my time, isn't it? Yeah. Okay, trade secrets. I have another war story here. This is again how much to keep as a trade secret and how much to put on the public register through filing a patent and having that published. There are some industries where huge amounts of information about the practice of a technology are actually based on trade secrets that everybody develops and keeps tight. Unfortunately, in this particular instance, the client found that they were a mining company and they were processing this mineral and they used water up in the Gascoyne where the ambient temperature is around 50 degrees. They also used as part of their processing an off-the-shelf chemical product which had certain features that everybody knew about. It's just an off-the-shelf product. Along comes a foreign company and they file for a patent in which they claim two features: the temperature of the water, which our client can't change without refrigeration, and the molecular weight of this common additive. So all of a sudden, here's our client stuck in the bind of, do they infringe this patent? Now, it's okay to the extent that they're already been doing it for years, but to the extent they want to authorise somebody else to do work on their behalf, they don't get the benefit of the defence in the Patent Act against infringement. So, faced with the question of, can they try and invalidate this patent either, first of all in opposition, or secondly by revocation? It turns out very, very few grounds upon which to attack this particular application of the patent, because there is nothing published about temperature or, in fact, molecular weight of this particular additive. So you do need to make the decision early on, are you going to keep it a tight trade secret? Is there any chance that at some point down the track somebody will come with some kind of left field patent that may end up erecting a patent fence around you that could affect your liability and independence?
So your advice is talk early
Talk
to an expert.
Talk early to an expert, and also be incredibly careful about who you do business with. And just because they're a huge company with a huge reputation, don't believe that they won't do something ruthless to you. They can and do every day.
Thanks, Stephanie. Watermark?
Watermark, yes.
Your 5 minutes.
Just an introduction. Worked for 11 years for a really large firm, Freehills, which is really good. You get great training, you learn the law, very disciplined, but you end up being a bit of a battered chicken at the end of the day, sitting in your office and churning out those chargeable hours. So it's not a pleasant working environment some of the time. Then went to Veld Extreme, started my own practice as a sole practitioner, working in the field of intellectual property and technology. That's great. We go for coffee all the time. We have a very relaxed lifestyle, but you've still got to make a living. There's that instance for hours of churning out work. The type of work I was doing actually didn't change that much. A bit of litigation, IP litigation, infringement, disputes over ownership, that sort of thing. And also the commercial side, drafting agreements, confidentiality agreement, license agreement, joint venture agreements, all sorts of agreements related to technology. And now Watermark, I think I found a balance. It's a boutique law and patent attorney firm where you're obviously work to do, but it doesn't have the big pressures of the retail firms. So it's a good working environment. So tip for IP, I think really one of the main things is to understand IP and to know what it is. What is intellectual property? Really it's just an umbrella term. I think it's the umbrella term under which sit the various categories of intellectual property. So you have to make sure that you bring yourself within one of the categories. So whereas intellectual property is the generic term at the top, you've got to decide which IP you've actually got, which IP you want. So your categories, the 4 main categories, there are others, the 4 main categories are patents, copyright, confidential information, and trademarks. And you've got to make sure that you bring yourself within one of those categories. So you've got to decide, am I going to get a patent? Make a conscious decision as to whether you're going to get a patent. Or are you going to rely on your information being confidential? Which of those is the better strategy? Copyright, now then, is great. Copyright is automatically, as soon as you create your copyright work, you have copyright in it. And therefore it's a very user-friendly IP regime. The difficulty with copyright is that it can be limited in the protection it gives you. I'll illustrate that in a second. And finally, trademarks. are slightly different. It's more about its branding, it's about the name. It's what people, the public associate your name with your product and making that connection. So just to illustrate the problems with having these various categories and fitting into it. I don't know if you saw, there was an article in Scarlett's paper, the West Australian, a few weeks ago about a guy who had developed a shark alert app. Right, so this guy here, he is, my apologies, not apologies, perhaps some free advice. And he was complaining that somebody else, I think it was a government department, had taken his idea and we're going to do the same thing.
Yeah, High Coast.
Yes.
Yeah.
Yeah. So they're basically going to do the same thing. He was not surprisingly up in arms about it. He'd spent tens, hundreds of thousands of dollars developing this app. And he went to an IP lawyer, the article said he was giving advice. So what IP did he have? Think patents. He hadn't applied for a patent. And it's most likely that subject matter wasn't patentable anyway. You can't patent just putting something on an app. So that wouldn't work. Copyright. Yes, he has copyright in the software. He also has copyright in the visual appearance of his app. But somebody else can come along, rewrite the software, do it, have different images, do the same thing. No protection for the idea or concept. So copyright, some protection, but it's not going to protect the idea, so it doesn't protect the guy with his sharp like that. Confidential information, useless. It's out there. He'd already published, he was promoting it. Anyone can come along and say, hey, that's a good idea, I'll do that myself. So you can very quickly lose your confidential information. You keep it tight with confidentiality agreements, but as soon as you get out there into the public domain, that's it. Your protection evaporates overnight in relation to confidential information. Trademark. Yes, he had a trademark, as Charlie says, for his product. That's easy enough. Somebody else just uses another name for another trademark. So patents, nope. Copyright, nope. Confidential information, nope. Trademarks, nope.
So no protection.
Ends up with no protection. And he spent hundreds of thousands.
What should he have done?
He should have spent $100,000. He should have looked at getting a patent, but I think he probably
Because he came out before that. He was a good year and a half before he was already out. And actually he'd been to see them as well. He was trying to get meetings with them. And then they come out and do the app. He goes, WTF?
Yeah.
You understand it,
That's right. No,
What could he have done different?
But if they were already working on it, it's paying money, so we should not-
Maybe they were quiet about it.
Well, I think it comes down to execution, being out there first, and having the public associate your trademark with the app.
So your best protection, maybe your only protection, is execution.
Yeah, speed to market, get that app recognised as the particular name you're giving it, so that people look at the others and think, well, that's not it, it's this one over here, which is the one over here.
All right. Thank you very much, Guy. Rohan.
Hi everyone. Well, obviously I'm I guess a patent attorney, but it's not quite the same as a lawyer. I won't go into that because time limited, but yeah, I guess what I wanted to focus on is the registered rights, the patents and the trademarks. Just to cover off technically, I don't know that it wasn't patentable. You know, it'd be a question of having a look at it to see whether it really was. If it was, then maybe there would be something that could have been done there. But
So
I guess
sorry to keep going on. The fact that he was out first was not protection.
exactly.
Okay.
Yeah.
That's maybe a misunderstanding. Maybe
Sure. Yeah, definitely. So I guess that is a perfect leading to registered rights. I guess the point being, to get a registered right, you have to seek to register it. You've got to actually be active and file an application for a trademark or file your application for your patent. I guess just to distinguish them a little bit more, so the trademarks really are about branding. So High Coast, the guys over there, so that's for the trademark. There's plenty of other trademarks that are out there. It's about protecting the branding. So if you have a good name for your product and you don't want someone else to use that name, trademark registration is the best way of protecting that. Not necessarily the only, but it's the best because it's an easy system to use to defend that reputation. Patents, on the other hand, don't protect ideas. They protect implementation of ideas. So how you do something. So if I have an idea about monitoring sharks, that's not protectable. It's how you monitor the sharks, the technical side of it. And I guess that is a common misunderstanding. People think I can patent my idea, I get phoned up often, I want to protect my new idea. But it's more than that that needs to be patented. It's the technical side of it. So sure, just because you have an app that can do something or a website that can do something, that's not enough. It's the how, and the how has to be both new and not obvious. Yeah. That's a whole talk in itself. But
the important point, new and not obvious.
New and not obvious.
That makes it patentable.
That's right.
But it's the how you do it, so the technology behind it, or how this machine works, so how you can patent that.
There's another important point with the new factor though, which is that you can't now go and file a patent application because it's now not new. Now there are some grace periods, I won't go into that too much, but essentially don't go out there and tell everyone about it or put your app out there in the marketplace and then expect to get a patent. Particularly in most of the rest of the world, they don't have a grace period. So you can't then go and say, look, my product's really successful, I'm saying it's copying it, what I do, now I'm going to go and patent it, too late. So you've got to make the decision really from the very beginning. Do I want to go and patent it? And I guess the other thing to say about that is, patents are costly, so you've got to pay some money for that.
Rough idea, ballpark to get going?
$4,000 to $6,000 for the sort of the first step. There's many more to come.
And then you've got to be prepared to protect if someone comes after you, and that could be expensive for litigation.
Sure, yeah. But I guess the key thing is, if you've got an app or a website or whatever that's going to be, trend of the month, and it's going to be around for a couple of months, and then everyone's going to move on, probably not worth it. But if it's going to be something that is going to last for a long time, and this is another thing that people sort of misunderstand. I've got my new product, and I'm going to have another one 6 months later, and then another one. If the same idea in that first product is going to continue through those versions, or the implementation of the idea is going to continue through those versions, then the patent covering that is going to extend through those versions. So the patent covers the invention, not the actual product or the version of the product. So if it's something that I guess and I guess most people don't go into the startups and I'm going to give it a go, and then in 6 months I'm going to go back to my day job. If you're going to give it a red hot go, people want to see success. They want this product to work over a good number of years. So it's a long-term aspiration. And protecting your IP is about protecting that aspiration. It's about protecting what I could get in 10 years' time, not necessarily what's going to happen in the next few months.
So investors want to see it as well. Investors want to see patent protection.
Very often,
if there's something patentable.
So I guess a quick example. Some of you may know Geo Moby, who's a founding institute graduate from a couple of years ago. So they're hopefully going to make some good announcements pretty soon. And that's the type of thing where they've got that patented, or at least it's under application. Because they don't plan on being around for 5 minutes, they plan around having this app continue for the long haul. And that's going to build into the valuation that they have in the long run. So, and patenting is not going to be for every startup. It's a question of evaluating.
How long does it take, typically? Because you've got to do the work, which takes a few months, and then you've got to put it in, and then there's a period where people can dispute your patent, and so you finally get it bang.
I guess the key time frames is, let's say, roughly a month from come to me and we get the patent filed. Because we've got a draft to work and all that sort of thing. Then you'll have a year from your provisional. You'll have a few more years before it's examined. And then you'll have maybe a little bit longer before it's granted. So typical time frame to grant might be 4 to 6 years, depending on the country. That's why it's about the long-term aspiration. It's not about the next couple of months. It's about what's going to happen in 5 or 10 years. when the underlying technology is used in maybe a few versions later of your product, what other people are then going, well, that's a good idea, we will replicate that. And then it's how do you stop that? Or how do you perhaps not stop them, but get a license fee from it? Because often licensing is actually far more valuable than keeping out competitors.
All right. Thank you very much, Rohan.
Thank you.
You got up early to come here and listen to some lawyers, so well done.
And a patent attorney.
And you've done well so far, sitting there quietly, and a patent attorney, which is not a lawyer. They must be bustling the questions, so hands up, far away. So, can you just say who you are and just if you're addressing it to the whole panel or a particular person?
My name is Ash. I'm a marketing engineer, and I'm trying to explain two things in the resource sector. The question that I have are two. The first question is, what is that tipping point when you decide you should go for a patent? Like in our last, I think, couple of months back, we were doing a workshop over here to pitch up an idea to the work, and then we went out for validation. There are about 17 or 18 teams over here. So when you go out for validation, you are telling public, this is my idea. And unless you don't do that, you don't really know that idea is going to work. So what is the pitching point? That's number one, or the tipping point. The second question is, what is the life of this patent? You said it's 4 to 6 years. Is there an expiry date?
Yeah, okay, the second one's easy to answer. Generally it's 20 years in the vast majority of countries. So 20 years from your filing of your complete application. So if you file it first, you can effectively get 21 years. So it's quite a long time. The first one is a tricky one because, you know, as a regular to start, we can validate. But you've got to balance that against what am I going out there validating? Am I giving the whole secret away of how I'm going to do this? Or am I just going, if you could do this, would you buy it? How much would you buy it for? You know, that sort of thing. So it's a tricky one. And there's no right or wrong answer. There's just kind of what you do and you live with the consequence of that. If you don't want to suffer the consequence of giving it all away and having it unprotectable, just be careful about what you tell people. There's kind of an, I don't want to get too technical about it, there's kind of an enablement requirement to, as well as the idea, you've got to also say how you implement an idea. So if you don't give too much away, again, it's at the end of the day, each case is judged on its facts, but at the end of the day, it's a tricky one. So you've got to basically take a balanced approach, but be aware if you do give too much away, then that door may well close and you cannot open it again.
So I've got 2 points to make. The first one is you really need to make it clear that if you're thinking that you may have grounds to apply for a patent, that it's very important that you do not disclose the nature of the invention or how it's practiced in the context of commercial negotiations. And you can have disclosure under the benefit of confidentiality ground without invalidating your application, but it's very important to not have orders lined up, for instance, for this invention if you haven't actually filed a provision. So it's very important to keep your invention secret, even, I know that's a hard trade-off because you want to gauge the market for this product that you think you can get a monopoly for. But on the critical question of how do you make the decision of whether to patent or not, one guiding factor that you might be helpful would be to consider whether, are you at an early stage in this technology? Is it, you know, at a really, you know, early stage of discovery and proving of the process or the invention? Or is it a later stage refinement? It's just an incremental improvement that other people have gone before with? Yeah? Clearly, if you're at an early stage, your chance of getting broad coverage is really good. You know? So I would have thought that would be at least one criteria that you could look at. So I hope that helps.
Fantastic. Lots more questions. Rohan. Yeah. Rohan always asks a question. Always in early. Always in the front. You're like, when I was a school teacher, you'd be like the top student, always in the front, asking a question. Bless you. Yeah.
Thank you.
My name is Rohan. One of the scenario that I always come across, my background is technical, so I talk to a lot of people. And when you talk, especially in the tech area, people come with ideas, and some like to get a confidence agreement. And it's always tricky to see, you want to talk to people to give them advice, but on their return, you don't want to commit to something that you might be overlapping with another person or another idea. So it's always not very clear, and I just wanted to bring it up and see if you have any good advice on that, how this can be practiced between startups to do this in a nicer way.
Sure, it's a real issue. I think it's for the person who's got the information is disclosing it. You're desperate to keep that, yours, to put a fence around it. From the point of view of the person who's receiving the information, they don't want to be prejudiced by signing an agreement and then finding out, for example, that they're doing exactly the same thing, and then they get into stoush as to actually who didn't invent it, what confidential information was used, was anything used. So there's two certainly conflicting positions there. And sometimes you can't reconcile them. I mean, I've had clients with inventions going to big companies, and big companies said, we are not signing a single document. You just go away. You can either tell us your idea, and we'll think about it, but we're not signing anything. So some big companies do that, and venture capitalists generally are not going to sign their NDA because it just might get in the way of something else is doing, and venture capitalists, the ego is to consider. But to try and have a practical way of doing it, it depends on the situation. But I think you can get around things by trying to define the confidential information which is going to be disclosed, which in itself is a different thing because you don't want to disclose the information. But what you're trying to do in your NDA is essentially say, this part of things is this is what we're going to be disclosing to you, this is what it's going to be subject to.
So it's a bit of a gut feel as to how much you're going to say.
Yeah, you've got
these guys look serious. I look at the white in their eyes. I'm going to tell them. I'm going to tell them enough that I'm going to know where the line is. And I don't think these guys are serious. They're just looking under the hood. I'm not going to tell them much. I'm walking.
Yeah,
that's my experience, and it's difficult.
If it's patentable and you haven't filed a patent by then,
Right.
then
You're opening yourself up.
yeah, exactly. You should have already got your application filed.
Questions from you?
Hi, my name is Rod. First question is, what's the difference between an NDA and a non-circumvention agreement? And then do you use both, or just one or the other? And the other is along the lines of doing the patent. If you're a startup, or trying to be a startup, and we're talking about bootstrapping here, it's a bit chicken and the egg here, because you won't be able to pay for a patent because most of your money is going towards developing the idea, developing the concept of an item. And you almost need revenue before you can go and do the patent. So how do we get around that?
So the first bit first.
First one's probably the easier
Non-cross
question.
agreement? I never heard of that.
Non-circumvention.
Never heard of it.
It's really the example that I gave first up about the axle. The NDA is for confidentiality, then the non-disclosure agreement is the thing that governs, I keep my information, you keep yours, and you get no.
And you must have come across this a lot. You still
Yeah, I guess. I guess the answer, broadly speaking, is no. Again, patent attorneys generally don't take on extra either. Say broadly speaking, because that doesn't rule it out. But I guess, at the end of the day, if you're going to run a business, you're going to have expenses. The question is this an essential expense for your business? How important is it over the long term? Again, we're talking long term, and if it is, find the money. It's as simple as that. I'm sorry.
But a cup of coffee
is
free, right?
$4.50.
Sorry,
Sure.
$4.50.
That's
First consultation.
But I will add this. Sorry, cut you off there. But you can file your own application, but I strongly advise you not to, because whenever we see, we just go, right, tear it up, throw it away, useless. I've only ever seen one well enough drafted application by someone themselves who hasn't had 5 years of training as a patent attorney. So yeah, IP Australia will tell you you can do it, but disaster waiting to happen.
Quick one, Stephen,
Okay.
more questions
Okay.
coming, yeah.
I have an ethical problem with the whole idea of taking equity instead of a fee, and that's because it puts me in the camp of the client. It actually prevents me from, makes me unable to give impartial advice. I think that there is conflict of interest there. You need to have your advisors who are prepared to give you their advice for what it is, to tell you the rights and wrongs of it and so on. As soon as my interests are merged with yours, I can't have that impartiality.
I think my question is for the non-lawyer, jump in. When you're patenting a code-based product, so your application website, what are you actually patenting there? Is it the code or the process the code's actually meant to do?
The latter. So the codes would be automatically copyright. The methodology or the process the code is doing on the computer, or configuring the computer to be, so a computer configured to be something, that's what we're patenting. It's the how it does it, the methodology. Typically, it's get a bunch of information from some sort of data source, do some sort of crunching on that, and then produce some sort of output to that. The methodology by which you do all of that is what's patented.
So with something like Facebook, is that actually patented there, or is it more trademark? I mean, the reason why I asked this about application is there's companies out there like Rock IT who make a lot of money through cloning. So there's a product or app, they build their own, they get a customer base and they flip it and they make money. So where's the benefit for a young app developer to actually patent his ideas? Should he more focus on getting a client base of his own, get to touch that nerve of the target market, rather than worrying about paying legal fees for a patent which can easily be cloned and replicated by someone else?
It depends what it is you're doing. So if it's something that's sufficiently technical, then it may be worth being patented. But there's a lot of things that aren't patentable. So without really turning my mind to it, Facebook probably isn't very patentable.
Yeah.
Certainly the brand is
Aspects of it, early aspects of it.
Early aspects of it,
The
yeah.
early social networking aspects of it that were new at the time.
But they chose a road, no, we're not going to patent it now, unless you're going to be the next Facebook or the next Google or the next thing, then you probably don't need to worry about that too much. But let me add this on. Google had a very early, we're not going to patent our stuff policy. And they've still been very successful about it, except that they went into the mobile phone market and they had to pay, forget the number of billions of dollars to buy Motorola's patents, because they ended up having to pay out all this money on license fees and then nothing coming back in. So they had to buy the way into that market. So if you're prepared to do that later on when you're highly successful, good luck to you. But maybe a better strategy for them might have been, let's get some patents early on in our own technology. It's a long-term game, the patent game.
5 minutes left, so 2 or 3 questions. Scott, then. Yeah.
Hi, I'm Scott. Trademark question. Do you have any experience with cloning with sorted.com using Australian
Cyber squatting. Oh, right.
Someone's sitting on your
Yeah.
name, .com.au, so you can't buy it.
No, you've got to say you've got the .com.au,
Right.
trying to get the .com in the US,
Right.
using the Australian trademark.
The trademark won't defeat the domain name registration. With the domain name challenge, you can take it, there's a tribunal, basically, administrative tribunal, where you can go and have, try and get an order that the domain name that you're seeking be vacated by the person who doesn't have a genuine need for it, he's just sitting on it for the purpose of extracting the profit. Yeah. Okay, so trademark, having a registered trademark won't assist you. I suppose it might assist you in proving that you have a legitimate business.
Yeah, my understanding was it was required by that policy to have a trademark before you could take that process.
Not necessarily. It will help you, because it can help you prove they registered it in bad faith.
That's right.
So that's
fine.
Yeah. If they're actually using it. Yeah, so I guess there's a difference between when you're just sitting on it or you're actually using it. So if you're actually using it in commerce, then they may be using it as a trademark. And then, as long as they're doing it in Australia, you then have potentially a trademark infringement. You can then use the registration.
And don't forget, with a trademark, although the requirement is that in order to maintain it, you should be exploiting it. You don't, people register trademarks all the time. It's not necessarily just per se proof of the fact that you are legitimately in business in that space, offering products or services of that character, you know? So I just warn you to not be, superficial about it. Yeah.
So there is a process, that's good news. Yeah.
Thanks. Kevin here. Fun fact, about 8 years ago I was offered a job as a patent attorney, which for better or worse I turned down. On a different path now. But the question is, I suppose back to the criteria for patenting. I suppose if the invention is using commercially off-the-shelf products, and there's no, if you look at component by component, from that perspective, there's actually nothing novel in the invention. Is it patented?
It's going to come down to whether or not the combination of off-the-shelf things is new and not obvious. So I guess if you put it in this way, so there's a reasonably famous patent on intermittent windscreen wipers, and that there's a long story behind that.
It moved, didn't it?
Yeah, it did.
I've seen the movie.
Yeah.
But look, if you sort of distill it down to basically that's a bunch of nuts and bolts, kind of off-the-shelf thing. I mean, it's not oversimplifying it, but at the end of the day, if you take those off-the-shelf things and you combine them in a new way, and it's not an obvious thing to do, and there's some sort of advantage in doing that, then certainly it's going to be patentable.
Time for one last question. We've got some lawyers here to answer your questions. One last one. No? Oh, I think we've answered. Oh, Raman's again. We've answered everything. What a great Here we go. Raman's in again for another bite. Go for it.
Okay, thank you. One practical question that, again, I come across in my practice is that I tend to do a lot of contracts between when I take a job as a group and the contract. Contracts, what's the best way? The question is, what's the best way to do contract? Is there an off-the-shelf contract that can be used, or should it be customized by every, because every scenario is different? And how can I minimize the cost? That's my question.
I saw them all shifting nervously in the chair when you said off-the-shelf contracts.
Obviously, customised is really good because every situation is different. You've got to be customised really. That's not to say that you cannot find good starting points on the internet. The trouble is, you can find some awful starting points. And if you don't know what you're doing, you can end up with some kind of American-based agreement with American terms, which just completely misses the point of what's you do. So any agreement has to, you start off with, this is the type of agreement I want to have, and then you have to customize it to get to the stage where it meets your requirements. So I don't think there's never really any shortcut to that. And sadly, again, you see bloody lawyers are going to charge us a fortune to do this. But the consequences of getting it wrong are catastrophic. So it's got to be worth it. I think it's part of the whole message here, perhaps, is that IP is worth thinking about, and it is worth spending money on. Because if you get it wrong, you're in a disaster. And you get it right, then you could be the next Facebook, Google, whoever, and be able to have a sustainable business. So I guess the lawyers would say that, wouldn't they? You've got to pay a bit of money to get it done properly and see it as an investment.
My big tip.
Yeah.
My big tip, and I have lots of clients who are in your position, early stage, trying to get the business up and running first of all, and that is to work on a term sheet first, where you work out the key terms. How long is it going to be for? What type of agreement? What territory? Exclusive, non-exclusive? Royalty rate? Is it going to be per piece rate of return? Or is it going to be an upfront fee? Are there going to be, sums to be paid just for the sake of getting a license agreement? So just for doing the deal. Those sorts of things. If you can work on a term sheet, work out the key commercial terms, and have the other party agree with it, and then bring that to your lawyer, that is going to reduce the amount of work that the lawyer has to do in doing the custom agreement. So my strong recommendation is term sheet first and get agreement with the other party on those key terms first, and then you're well ahead of the game. Okay?
I guess a question that I've often come across in this sort of context but wasn't asked, so I might ask it, is about incorporating your startup and getting the IP into that incorporated body. So perhaps I'll throw that to my fellow panelists.
Question from the panel to finish with. Yeah.
Oh, okay. There you go.
I'll look. Again, it depends. Generally speaking, I've had situations where you desperately want to have a corporate structure. It's best to have a proprietary limited company. There's a number of reasons for that. Limited liability, getting investors in at a later stage, having a known structure. Tend to avoid trusts. By all means, have the shareholdings in your proprietary limited company owned by a family trust, that's fine. But have a clean proprietary limited company, which is the entity which is operating. If you want to get a little bit fancy, you might have two entities, one holding the IP and one operating. And that can have the benefit of if the operating company goes belly up and goes under, you can keep hold of the IP in your IP holding company. And that sometimes is relevant to have that structure. But you know, my recommendation would be a proprietary company.
Okay. When I asked these three a few weeks ago to come along and do an IP, patent attorney, copyright, trademark, chat to startups, they immediately replied within 5 minutes, each of them, yes, of course I'll do it. In fact, Guy had been nagging me for about a while. I'd love to come and talk to them. So one of my desires in my position now is to get startups to meet corporates and corporates to meet startups. So this is certainly, I think, the view shared by Justin and Steph in Morning Startup. So thank you very much, the three of you, for coming along. Thanks you guys for coming along. Give them a big round of applause. Justin always says we've got the room till 9. If you're on a folded chair, can you put it back?